exciting week by once again recognizing those who have made this possible, and then we will have a very stimulating speech to close the program. Before I give those thank yous, let me also indicate that the program is on a tight schedule this morning because following this speech, there is a 6-hour, rather intense workshop by our distinguished speaker today that people have signed up for, pre-law students, attorneys, and some educators on campus, and some students from Lewis Clark State College. So please forgive us if we have to go away quickly because the workshop starts at 10 o'clock. The North Idaho College Popcorn Forum Series is closing its 21st year, 21 years of celebrating ideas and open discussion on this campus. We're delighted at how this week is added to previous years. I think this year is particularly successful, however, because of the cooperation of other organizations. And what we've done over those years is, number one, due to the fact that the Associated Student Body of North Idaho College has funded the series, and I want to personally have you to join with me in saying to the student government and all the students at North Idaho College, thank you for your funds over those 21 years. Number two, I would really like to express a deep appreciation to the North Idaho College Convocation Series, which has been in operation many years also, and a very, very great person, a great teacher, and that's one of the great occupations in life, who chairs the Convocations Committee, had the wisdom to, I think, convince her committee that this was the route to go, and I want to thank especially the entire committee and the chair, Lynn Maddie. And we had a new sponsor this year. We have celebrated the 100 years of our great state over the past year of the Centennial. And about 4 years ago, the Idaho Centennial Commission was put in place, and it's had a lot of workers, and that commission saw fit to grant to us a $5,000 appropriation. The chair of that commission was here on Monday, Harry Magnuson, and a member of that commission is really one of the most active members, and she's worked with us all the way through. And I want to say, as a dear, dear friend and a great visionary person who will also introduce our speaker, thank you, Sue Flamia.
Goodness, such eloquent praise. Thank you, Tilly. I just want to tell you that this has been a very special week to me personally. I told Tony, I feel as though I've had a vacation. I had this opportunity to think about all of these wonderful concepts, to reflect again about the importance of the First Amendment in our lives, and how important it is that we acknowledge this freedom exists, acknowledge the tensions that are always there, and through the celebration of the First Amendment, we all are enhanced as human beings, our own personal rights, within our families, within our communities, and of course, globally. So I congratulate all of you for the partnership that enabled this series to happen, especially Tony's leadership in bringing us all together, the students for participating, the college for participating, and for the Centennial. And I, again, would like to say, on behalf of the Centennial Commission, the leadership that was provided by Harry Magnuson has enabled allocation of resources throughout the state to enhance all of the programs, particularly giving us the opportunity to think about the future, which is what this program has been tied into, the project of the second century. We have talked then all week about different ways of viewing human rights and the First Amendment, and we've been talking about the inherent conflicts that exist within our culture. Today, we are privileged to have with us Bryan M. Johnston from the Willamette Law School, who is going to talk to us about dispute resolution and constitutional rights, friend or foe. This is, I think, a very important opportunity to give another way of thinking about resolving these conflicts that inherently exist. Bryan Johnson is currently the Associate Dean of Willamette University's School of Law. Previously, he served for 3 years as director of the Center for Dispute Resolution at the College of Law. He is involved in teaching, training, arbitrating, mediating, and other dispute resolution activities throughout the Northwest. Before joining the law school, Mr. Johnson was a trial attorney in private practice in Salem, Oregon. I first met Mr. Johnson at Peaceful Settlements, another project specifically to give us a forum to think about other ways of resolving disputes. He earned a law degree from Loyola University of the Chicago Law School and an undergraduate degree from Northern Illinois University in DeKalb, Illinois. At one time, he was a Vista volunteer, and he has served in the Legal Services Corporation and as a public defender. He's also an associate professor of law at the college. He teaches a mandatory course for first-year students entitled Dispute Resolution Processes, and in the past he has taught other courses such as evidence, trial practice, and so on. He's also written a book, Ending It, Dispute Resolution in America. So we are very privileged to have with us today Bryan Johnson.
Thank you very much. It's a pleasure to be here, although something I said or am about to say has caused everyone else to leave. Let me share, I am very pleased to be here. I'm very pleased not only to be in North Idaho, but to live in a country where we can discuss the issues that you've been discussing this week and have it be more than an academic exercise. We can discuss things because we as citizens own those things, and we can make an impact on the outcome of the way in which our courts apply our laws. I'm going to speak to you today on the question, dispute resolution and constitutional rights, friend or foe. My job, of course, this morning will be to speak. This is a line borrowed from Adlai Stevenson in his second presidential campaign. Yours will be to listen. I hope we finish up about the same time. The topic, as I started to think about it, is amazingly broad. As I introduce it, I hope you'll share that conclusion with me. I was reminded of a story from Winston Churchill. He, as many of you might know, was not a teetotaler. And during World War II, he increased his not being a teetotaler significantly. He was visited once by a representative of the Women's Temperance League at 10 Downing Street. She looked around his huge office and said, "Winston, you're setting a terrible example. During this war so far, you've drank enough brandy to fill half this room." And Churchill looked around and said, "So much to do in so little time." Well, that's the way I feel about the next half hour. Okay, well, we better get started then. Let me tell you what I intend to do. I intend to define constitutional rights and dispute resolution for the purposes of this speech. I intend to draw some conclusions from those definitions, to rephrase the question that is the title of the speech, and then to answer it. Okay? Let me give you, for those of you who like to read the last chapter of a mystery novel first, let me give you the answer now. Dispute resolution, friend or foe? Yes and yes. Okay, with that in mind, let's go forward. First, constitutional rights. Well, let's break the phrase in half. Rights. Generally, when we in this country talk about rights, we're talking about power. We're talking about the power to do or to refrain from doing something. And someone has rights, they have the power to do those things. In fact, our Bill of Rights enunciates certain activities that we can do if we so choose. We have that power. Constitutional means that those rights are acknowledged and protected by the Constitution. Now that becomes very important. Other documents might acknowledge rights, but do they protect them? The Constitution is the supreme law of the land, of course, and it offers the protection. We all endure certain rights. You have rights under Idaho contract law. You have rights as a citizen of this state. You have rights as a citizen of whatever state you belong to. But different states can prescribe and give different protection levels to those rights. For example, Oregon's Constitution extends rights of privacy that exceed the guarantees of the U.S. Constitution. For an Oregon attorney to go into court and argue a privacy issue, he or she should start with the Oregon Constitution, because that document protects rights further than the U.S. Constitution. Similarly, in different jurisdictions, you'd have different approaches to the rights issue. The question simply is, if we are addressing constitutional rights, then we're addressing those rights enumerated, authorized, articulated, and protected by the Constitution of the United States of America. Okay, definition number one. Definition number two, dispute resolution. First of all, let me tell you it's a term of art. And as a term of art, it's a term in transition. Generally, even as short as 3 years ago, I would have defined dispute resolution to you as alternative dispute resolution. And we would be, in fact, that's the title of the workshop that I'm doing this afternoon, alternative dispute resolution. And that question begs, what is it an alternative to? And it's an alternative to litigation. Litigation is the process by which a lawsuit is carried to its conclusion. Litigare comes from the Latin, and it means carrying on. Okay? Litigation means the carrying on of a lawsuit. Courts protect constitutional rights. And litigation is the mode by which that protection is accessed. You gain access to the courts by filing a complaint. Someone responds to the complaint. And then the courts, as if you're on a little treadmill, work, perhaps not quickly, but work to reach a resolution of the questions presented. Okay. That's litigation. Alternative dispute resolution, then, are other means of resolving disputes alternative to the court. I say it's a concept in transition because dispute resolution has become, as we've talked about it and thought about it, and academics have written about it, has become a slightly different approach, a different feel about the resolving of conflicts. And I would now suggest to you that dispute resolution really means the resolution of conflict by interests. And to use that definition, I would have to expand my field of inquiry just a little bit and tell you that there's really only three ways that we can resolve disputes. One is through power. We've just seen an example of that in the Iraq-Kuwait affair. The resolution of a dispute by power. We tried negotiation, and I'm not going to make any comments as to how long we tried it or how well we tried it, but we tried negotiation, and we were unsuccessful. There was no court of law to which we could turn to achieve the result we sought, and so we used power, and power ended, at least the possession of Kuwait, power ended that question. So one method of resolving disputes is through power. One method of resolving disputes is through law or rights, a rights-based premise. And one method of resolving disputes is through interests. Power adheres to, obviously, he or she who is most powerful, the person who has most the authority to impose their will. Rights come out of some concept of legitimacy, some concept of law, some concept of there's a document, a finite award of power that is going to be enforced by some middle person. Interests are consensual. They say, what did people agree to? So when we talk about dispute resolution, we're talking about that third category, the consensual resolution of the dispute. Okay? Take, for example, just so we can give that concept of three ways of resolving disputes some flesh, take, for example, the labor movement in America. Originally, all power inured to the owner, the employer. And for years, that's where the power resided. There was a sign over the boss's desk that said, my way or the highway. And those were the alternatives. Okay? Power rested with the employer. Then the unions began to exercise some counterbalancing power, or attempt to. And you had such things as the Haymarket riots and labor unrest in this country, until you finally got to a point where the U.S. Congress began to enact laws. And so then the labor movement moved from a power-based resolution of disputes, did you have the power to get what you wanted, to a law or a rights-based resolution of disputes. There are certain rights as acknowledged by the U.S. Congress. Here are the rights, you can enforce them or choose to enforce them, and it becomes a rights model. Now we have attempted to move in labor to an interest model, where they have interest-based negotiation, where they have grievance mediation, where you have attempted to create a model where parties consent to how they're going to govern the workplace together. Okay? Moving through all three. Now, if you're unsuccessful, of course, then you revert to another model. The strike, I would suggest, is an example of the power model. We're going to bring this company to its knees, and we strike. That would be an example of the use of power. On the other side, we're going to lock out the workers. That would be an example of power. So you can float back and forth between these three models, but they're only really the three models you have. Ironically, when we talk about alternative dispute resolution or dispute resolution, we're talking generally about three core processes: negotiation, mediation, and arbitration. Those three processes, interestingly enough, are all much older than litigation. Litigation is the baby of the foursome. It's about, depending on how we want to argue over how old it is, about 700 years old. The rest are, examples of them can be found throughout all of history. So we have the youngest being the engine of dispute resolution in this country. The other three, and their hybrids, are called dispute resolution. And now the question then that we've originally posed here is this concept of dispute resolution friend or foe to constitutional rights? Well, let's combine the two and see what the question means. Constitutional rights, a power acknowledged by our government, is a destination. It's something that an individual wants to know he or she has so they can decide whether or not to exercise it. That's a place where we will wind up. I would suggest to you dispute resolution is the journey. It's the process by which we get from where we are now to some destination. The process that the courts use, litigation, takes you from here to there. And the theory is, hopefully, it takes you to where you have acknowledged that constitutional right. Now the question becomes, what about these other processes? Since they go in a different manner and may arrive at that same square or may not arrive at that same square, are they friend or are they foe to constitutional rights? Well, as I pose that question, you might have posed one yourself, which is, what's the big deal? I don't get it. And I would suggest to you that there are two problems with dispute resolution as an alternative vehicle to arriving at a destination of constitutional rights that one needs to consider. The first question, I think, is ill-founded, and it's, well, someone in a negotiation or a mediation or an arbitration where the courts don't have control, someone might settle for less than they're entitled to under the Constitution. That's the first question. And the second is, I think, far more important and well-founded, although the individuals might disagree. But the second question is, what about the rest of us? What about our interest in those constitutional rights being enunciated? Let me give you an example with some flesh. This is the front page of yesterday's USA Today. The headline reads, "Women Win High-Risk Jobs." The cover story title is, "Fertility Issue Could Affect 20 Million." The point of this is that we have a question that has gone to the U.S. Supreme Court. And the question was brought about by a 40-year-old woman, I think she was 48, a woman of at least the upper 30s, who raised the question because she wanted to make the increased salary that a line worker made in the battery factory. The difficulty was, line workers in the battery factory were exposed to lead. And lead could endanger a fetus. Consequently, the company had adopted a program saying that if you wanted to work in the line, you had to be one of two things. Either not capable of carrying a fetus, that allowed the men to work in there, or sterile. Now, other women before this individual had resolved that differently. They had sterilized themselves, taken the job, and gained the increased salary, or they had chosen not to take the job. Those were their options. Now the problem comes, what if we decided to litigate this dispute? Well, here's the answer. 8 years later, it goes to the U.S. Supreme Court, and the U.S. Supreme Court says the law means what it says, we have an equal employment opportunity workplace here. You can both expose yourself to hazardous work sites. Okay? If we had mediated that dispute, if we had sat down at a table and come up with some resolution, we might have worked out a resolution fully acceptable to the parties. The employer might have agreed, and the employee might have agreed, that they would work out a deal such that she might have a slightly different job and make the same money that a line worker made. And I would suggest to you that she would have been happy. From everything I've read about the case, her goal was to make the $350 a week instead of whatever she was currently making. Once they had worked out a deal where she could have made the $350, I think she would have signed off on it. What about the other 19,900,000 and some women in similar situations? What about their rights under the Constitution? What about their rights to make that choice? They, at this point, would not have been answered. You see, right now, what we have done, what she has done actually, by deciding to go forward, is she's forced into the legal documents, the legal annals, the precedents, the laws that are the norms for you and I, she's forced into them a precedent saying that a woman can choose to put herself at risk if she so decides. If she had settled that case at the table, that precedent would not exist. So, in answer to my question, is dispute resolution a friend or foe? We come down to a much more concrete question. What's the impact on the rest of us of settling claims that involve constitutional rights? In the example I just gave, you would think, oh, well, that's just onerous. See, we need that precedent. So we should discourage the use of dispute resolution when a constitutional claim arises. And we should encourage these people to set aside their own lives, set aside their own goals, set aside their own ambitions and some significant period of their own lives and fight this thing out. Because it's good for the rest of us. Therein lies the conflict. How do we balance the individual's right to exercise his or her own free choice with our interest, and it is a bona fide interest, our bona fide interest in advancing the state of the law? At the trial level, the lower court level, every case consists of two things, a question of fact and a question of law. When it's resolved at that level, it is resolved for those two parties and for nobody else. When that question rises above the trial court level and goes to a court of appeals, it's resolved for all of the people in that jurisdiction. Or if it's a federal case and it goes to the Ninth Circuit Court of Appeals, it's resolved for all of us living in the Ninth Circuit. When it goes to the United States Supreme Court, it is resolved for all of us, period. So how do we balance those two things off? Well, I would suggest to you that they are balanced off in a natural process anyway. Out of 100 cases filed in American courts today, less than 5 go to trial. Of those 5 that went to trial, if we collect all those 5 and come up with another 100, out of the 100 cases that went to trial, less than 8 will go to appeal at the first level. If we collect all those 8s and add them up and get another 100, how many go on to the Supreme Court in that jurisdiction? 2? 3? You see, there's this natural winning process anyway. And that process that I say started at the trial court level, you and I both know started well before then. It started well before the people decided whether or not to take it into court. So there's a big pyramid where only a few cases are rising to the top. And those cases that rise to the top, and I don't mean that in a value judgment sense when I say top, I simply mean descriptive. Those cases that rise to the top go on to present the question. Those become the cases that either advance or retard social movement. And it is erroneous of us to think that they will always advance. What they do is they frame a question. As you well know, there's a number of issues that people are dying to have come before this Supreme Court in the hopes that this Supreme Court is going to take a slightly different turn than other Supreme Courts. So the question as to whether or not you would take it up to the Supreme Court is a valid individual question. Now, I would suggest that There's a different way for us to look at this, and I would suggest this way. There's a maxim that people learn in law school, and it goes sort of like this, that tyranny begins where law ends. And people are fond in the first year of law school of repeating anything that sounds philosophical, and so they walk around the halls repeating things like, tyranny begins where law ends. Okay, well, let's accept that for a moment and say tyranny does begin where law ends. So that says that my power definition of how you resolve conflicts is true, and that if the law ends right here, tyranny takes over and it becomes he or she with the most power that will resolve disputes. I think that's true. But I think there's another end of the spectrum, too, that we ought to explore. And I take this quote from a man named Jerome Auerbach, who wrote a book entitled Justice Without Law. And Auerbach's quote, I think, establishes the other geographic perspective. He says that law begins where community ends. So we've now got both ends of the spectrum established. We know that when law ends, tyranny takes over, power is the answer. And I'm arguing that where law begins, at that point, prior to its beginning, community has taken over. So there's a communitarian interest at the beginning and a power interest at the end. And in the middle is law. And I think that's exactly right. That's how it should be. We should not be afraid of exercising our community interests. I'm not suggesting that we exercise these community interests to the avoidance of the court system. The court system must exist, and it's the appropriate place to resolve those things that we cannot otherwise resolve. But the first choice of resolving disputes should be in the community. The people should have an opportunity to sit. The people should have an opportunity to talk. One of the things that will, of course, influence the community is the concept of marketplace arising out of the law. How would this be resolved if it were indeed a legal case? That will happen. And if the people aren't satisfied, then they can take the other turn and say, either we resolve this together in an amicable way, or we go to court. You see, but most situations are situations where the individuals never spoke, where the individuals wind up in court without having had some help in resolving those disputes themselves. We can provide that. We can provide it as a society. I think the answer to that original question, which was, is it dispute resolution, is it the friend or foe, is yes and yes because of this. It is the friend of constitutional rights if it makes us more of a community. If our constitutional rights can gain wider acceptance so that they are more readily accessible to you and I as we confront the daily problems that we live through. In that respect, it is its friend. Dispute resolution is the foe of constitutional rights if we make an individual go through too many hoops before they can stand for their rights under the law. If we say, well, wait a minute, before you sue, you have to mediate. After you mediate, then you have to arbitrate. After you arbitrate, we'll have a settlement conference. And then, if you're still not happy, we'll go ahead and have litigation. And that'll be the option. Then we've made it too onerous. It's already tough enough to get through the system. But I think we as a society owe ourselves the opportunity to grow as a community. And you grow as a community when you try and resolve those differences. John Stuart Mill wrote, if all mankind minus one were of one opinion, and only one person were of the contrary opinion, mankind would be no more justified in silencing that one person than he, if he had the power, would be justified in silencing mankind. I don't want to silence that individual. I want him or her to have the opportunity to take their case as far as they should, as far as they can, as far as they think they need to. But what I want them to do first is I want them to sit, to talk, to listen, to understand what the community is saying, to understand what the community's values are, and then to make a choice. I think it will educate the individual and educate the community. So I answer the question, yes, it can be the friend, and yes, it can be the foe. And I'm reminded there was a trial judge in Salem, Oregon, who was, one day there was an argument in front of him, and one side had finished the argument, and the judge looked up and said, you're right. And the clerk said, you have to let the other side argue. So the other side came up and they argued. The judge said, you're right. And the clerk leaned over and said, Your Honor, you just told them both that they're right. The judge looked at the clerk and said, You're right. Okay. So having answered the question, yes and yes, I think that the future for our application of constitutional rights lies both in the court's hands and in the community's hands. We need to do more of the things that your community is doing, struggling with our rights, struggling with understanding them, struggling with coming together as a community to enforce them. I think that the answer deserves to be in the affirmative on both counts, and I'd be glad to take any questions that you might have. Thank you. Hearing none, I'd be glad to let you go. Oh, yes, sir.
Can you cite an example from your experience where a community like this could establish some sort of dispute resolution forum or network?
There's a couple different models of that happening right now. The American Bar Association has a number of experiments. They're called multi-door courthouses, where you would take a dispute just as you would your case to be filed to the courthouse. But before you would file it, someone would read it and say to you, would you be willing to arbitrate this or mediate this or have some assistance to negotiate this before you file your case? The person says yes or no. And if they say yes, then they set it up for them. And someone who is trained, for example, let's take the case I was just talking about with the workplace dispute. Now a woman in Texas, I don't know where this company was, who's in a similar situation where she's been denied an opportunity to do something based on this hazardous concept. And she decides that the only way she's going to make any progress is filing suit. She files suit. The company says, oh, we're not responsible for that. We don't have to do that. And they answer in the negative. It's still going to take her 3, 4, 5, or 6 years to enforce her rights. Someone says to her, would you be willing to sit down? She says, I am. So they say to them, would you be willing to sit down? They say, yeah, we'll sit down. They sit at a table, and someone listens to both of them, understands what they're saying, then meets with one side alone and says to the other side, I don't know if you've been paying attention to the papers, but have you seen this case? He said, yeah, my attorney says that case doesn't mean anything. Well, you might want to talk to your attorney about and helps them get a grasp of what the situation really is. And I think that speeds the potential for settlement. Another example, Title VII, which has a wide variety of protections. They're currently mediating Title VII disputes in Northern California, Washington, D.C., and a number of other places. So those things, the programs can be designed to fit into a community structure.
Well, are you saying that attorneys set up dispute resolution mechanisms?
Well, that's one example. Attorneys set it up. Another example is the community boards of San Francisco. That's the attorneys can participate, but only as citizens. In fact, their participation isn't solicited, or even, I don't want to say not welcome, but it's not the goal is to have a wider variety of people sit on the panel that helps people mediate. And they mediate in groups of 3, 4, or 5. Lawyers need not control this process. In fact, it's a major mistake for us if lawyers control the process. Lawyers are citizens, and this should be representative of all citizens. Yes, ma'am.
Well, as a feminist, I applaud the decision that women do what they want to, as happened. The other that were involved in the Superfund cleanup, where we know all about the terrible effects of lead, particularly. And so I don't know where I am. Certainly it shouldn't be settled by law. It should be
Well,
other kind of resolution rather than the law saying you women have the right to do what you want to do because they don't even know what they're doing to their own bodies. Lovely.
that's what the point I tried to make when it's equal opportunity to exposure to hazardous materials is kind of it's a hollow victory at best. Yes, ma'am. The question was, what do you do when you think your constitutional rights have been violated by the court system? And the answer is the only mechanism to enforce constitutional rights that has power over the court system is another court. You have to find either file it in that jurisdiction, or if you're in the state of Idaho, for example, take it to the federal courts, but you have to find in a court. That's a rights-based resolution system, and you have to be in the court system to alter the court system. Yes, sir.
As part of Martin Luther King's approach to the civil rights movement, he spoke about the development of a beloved community. Do you see that as part of the concept of dispute resolution? How do you see King's approach to the use of dispute resolution, the use of the law, and the approach to force or power?
Okay. The question was reflective of Martin Luther King's philosophy, and I would say that I see King's philosophy in his letter from the Birmingham jail, for example. He talks about law and its appropriate and the obligation on people of conscience to, when law is wrong, to go against it. I think that he was presaging much of this movement when he talks about community and that setting the values. There needs to be, though, and this is where I would slightly disagree, there needs to be a safety valve to that community concept. Because community concept, and I think there is a communitarian movement developing these days, community concept without a safety valve will harness individuals just as rigidly as a totalitarian government will. There needs to be some safety valve, and I think that's the appropriate role for courts, to provide that safety valve release so that individuals can exercise freedom, even if it's counter to the community's senses of values. Nude dancing comes to mind, not necessarily because I'm a fan, but because it came to mind. But that's one of the that's an example of where the community's values might be rigidly opposed to nude dancing, and the individual, I think, has a right to express and to seek redress if someone was to prevent him or her from that activity. Yes, ma'am.
I see all resolution as power-based, whether it's in the court or whether it's on, the battlefield. Even when you go to court, it seems like the more money you have, the more power you have. And I see a lot of cases, especially where in a dispute like a divorce, if the woman, or it doesn't matter, if the person who's got the most money has those rights.
If I can change the phrasing of it a little bit, then I can agree. They don't have the most rights, but they have the best ability to either access them or to prevent the other side from accessing them. The rights will remain constant. There's a legal sociologist out of the University of Washington, Mark Galanter, who's written a brilliant article entitled "Why the Haves Always Do Better Than the Have-Nots in Litigation." And that he makes your point exactly. And that's true. The access to legal representation is one of the mechanisms by which people can use power in the rights model. And even in my argued for alternative, the interest-based model, the presence or absence of power is going to control what people are willing to settle for. If you're confronted with a lawsuit that's going to take you 5 years to prosecute, you may be willing to settle for considerably less than you are otherwise entitled to, because the settlement is the proverbial bird in the hand versus the long-range bird in the bush. That's why women's movements, for example, have frowned recently on mediation as the avenue of settlement in domestic relations cases. They approach it with some guarded concern. I'm afraid the time has come for me to move into another spectrum. Thank you very much.